Stay tuned for the next edition of Zoom Landlord Tenant Talk Radio. The opening topic will be Landlord Goldmine-Building an ADU on your property. Hello, yes, another edition of Zoom Landlord Tenant Talk Radio coming at you every Saturday at 3 p.m. If you were listening live, the name of the song was God Bless the USA by Lee Greenwood. And I felt this was apropos with that political assassination of Charlie Kirk. And I thought we needed to have an uplifting song regarding our great nation. And of course, the passing of Charlie Kirk. Okay, let's talk about the show format. And that is that we have an opening topic. And then after the opening topic, those people that are in the Zoom meeting room, I will call on you for your questions and answers. If you want to talk to me, please just electronically raise your hand. You'll find that in the bottom of your toolbar there. If you don't see it, then there's a folder called reactions and it might be in there. And I do call on the people in the order that their hands were raised. So do it now and you'll make sure that by the end of the show that I did get to answer your question. If you're watching this on YouTube, hit that like button and subscribe to the channel because it really does help. Also, if you want to, you can leave comments and I will get to answer those comments if you're not doing this in the Zoom meeting room. And by the way, for you people on YouTube, if you do want to join the Zoom meeting every Saturday at 3 p.m., it's pretty simple. Just go to my website, evict123.com, and you'll see the credentials if you do want to join live and also have your questions answered on air. Okay, let's move on to the opening topic, and that is Landlord Goldmine-Building an ADU on your property. Now, make no mistake, California is dramatically unfriendly to income property owners. This state boasts the highest income tax, the highest sales tax, the highest gas tax, the highest electricity rates, and of course has probably the most severe rent control. As property owners, we need to take advantage of any law that's in our favor. And the ability to add additional units to your property in the form of an ADU or a junior ADU means substantial increased revenue for you and of course, extra value to the price of your property. Now, California has done something good for a change, and that is they have instituted laws which require municipalities to accept accessory dwelling units and also junior ADUs. The key aspects is that cities and counties are now mandated by the state to permit ADUs and accessory dwelling units. In fact, the state has stated as of January 1st, 2025, that municipalities have to have in place pre-approved ADU plans so that architects can submit these plans to the city to review and accept, which significantly speeds up the approval practice. Also, another interesting note that the state has forced municipalities, they are forcing municipalities to accept illegal units. So if you have that illegal unit, that 8 unit when it's only a 7-unit building, or somebody's illegally converted a garage, they have to accept that. The only exception would be that it has to be permitted due to health and safety codes. So as long as they have a checklist, which they are mandated to do, you can take that illegal conversion and you can make it legal. Now, if you do have an existing illegal conversion, it's not permitted, you are going to first have to ask that tenant to move. If your property is located in a non-rent controlled area, or for example, if it's subject to statewide rent control, you are going to have to offer that tenant relocation money, but don't despair. It's only 1 month's rent. However, if your property is subject to a local rent control ordinance, like the city of Los Angeles, you're going to have to go through an application process with the city. You're first going to have to get the building and safety to declare that this is an illegal unit and give you an order to comply. Then once you have that order to comply, we can go through an application process with the city get it approved, and then we'll serve on that tenant a 60-day notice to vacate. Unfortunately, we've got to pay relocation. I'm just going to, as an example, for the city of Los Angeles, and I'm going to share my screen with you right now. You're going to see that the relocation, if your tenant has children, for example, and has been there more than 3 years, you're looking at $25,700. So that's if they have children or are over 62. Otherwise, it would be around $13,500. So you're going to need to first get rid of that tenant in that illegal unit. But then once the tenant is gone, and again, for statewide rent control, or if you're not under any rent control, that would be only 1 month's rent. But unfortunately, some of the municipalities, such as Los Angeles, does have hefty relocation. But once you get rid of that tenant, or if there was no tenant there to begin with, you then have the right under state law to get that unit permitted by going through that process. Now, if you have existing tenants, let's pretend in a duplex, and they have use of the garage, which is in the back of the unit, and you want to now turn that garage into an accessory dwelling unit. So now you'll have that extra income, and also the value of your property comes up. If you're in a non-rent controlled area, or even if you are under the AB 1482, the Tenant Protection Act, all you have to do is serve a 30-day change of terms of tenancy and tell those tenants that you're no longer going to be able to use the garage because I'm building an ADU. Now, relocation, or let me put it this way, reduction in rent. You don't have to give any tenant a reduction in rent if you're under statewide rent control, or if there is no rent control. You just serve a 30-day notice, you no longer can park there, and then you start your construction process. Now, if your property is subject to a rent control statute, such as Los Angeles, then when you serve that 30-day notice to change the terms of the tenancy, that you can no longer use that garage, you're going to have to give them a corresponding decrease in rent. So let me show that. I have that up now. And as you can see, for parking, the decrease in rent, which I have right here, if you can see that, is $75 to $247 reduction. And that's determined based on how much street parking. If there's a lot of street parking, then the reduction in rent is less. If there's little street parking, then it would be more. You pick the amount of what you're going to be reducing your rent. Let me stop sharing here. You pick the amount upon which you're going to be reducing your rent. And in that situation, if the tenant disagrees, they're going to have a meeting with the Los Angeles Housing Department. You'll come down there, and an arbitrator will determine what that amount is. Okay, so that's where you have existing tenants, and now you're going to take away their garage, their parking, because you want to now have an ADU in that spot. Now, there's many rules dealing with construction. How much is it going to cost? So I want to turn our attention now to a company that I deal with called Sturdy Builds. And there's one of the agents of that company, Della Razavi. I have her on the line here, but I just want to let you know before I put her on that she and her company was clients of mine. They used me for their eviction cases. But in addition to that, I used them to do 2 earthquake retrofits on 2 of my buildings, and I highly recommend this company. And now we're going to bring on Delia right now. And I'm going to ask you to unmute yourself.
Hi,
Hey,
Dennis, can you hear me?
Yes.
Good, how are you?
I'm good.
Thank you for having me. And
And I
thank you for the
appreciate that.
introduction.
Let me
Yeah, of
ask you
course.
something. How long has your company been in business?
So we've been GC for over 15 years, but our main focus is on the retrofit, the ADU, as well as the balcony inspection. We've been doing all of them since day one that they've been mandated by the state, some of them by the city.
Now, how do you determine if a property is eligible to build an ADU or a junior ADU, whether it's like a single family home or whether it's a multi-unit building?
So pretty much any building in state of California can build the ADU. As far as taking away the park, as long as the building is half a mile or less away from any public transportation, they can take away the parking legally and they don't need to replace it, which is the case for 95% of the buildings at least.
And what size can you build and how are those setbacks where you have to be away from other properties?
So it really depends. So if you talk about the attached is converting any non-habitable unit space, right? So it could be a parking, it could be a laundry room. Those we don't need a setback. It's just a conversion. We can add up to 25% of the existing units. So let's say if the building has 8 units, we can convert to ADUs. They can go as 200 square feet. They can go as big as 1,200 square feet. As far as detached goes, they cannot exceed over 1,200 as well. So same thing. The setback is 4 feet away from the property line.
And just for the audience, what's the difference between an ADU, an accessory dwelling unit, and a junior ADU?
So the junior ADU is for single family home, right? They are just a completely a different category. It's attached to the building because our main focus is multifamily. But what I know as far as a single family is the junior ADU is for single family homes, which is attached and they cannot exceed, I believe, up to 500 square feet. For multifamily, we don't have a junior ADU. It's just ADU attached or detached.
And how many ADUs can you add to a property?
So, like I said, for attached, we can go 25%, right? So let's say if there's 8 units, we can add two more. For detached, however, it used to be two detached maximum. Doesn't matter how many units there are, as long as you have the space, right? With those the setbacks, but they recently changed it to 8. But you can add 8 detached if you have enough space on the lot, but it cannot exceed over the existing. So if the building has 7 units, you can add 7 detached, but the max
Now,
is 8 if it allows.
got it. And if you do create an ADU, do you have to allow for parking for that ADU?
No, you do not. It's going to be the same thing. You can take away the parking, the existing parking. You don't need to replace it, nor provide the parking for the new ADUs, as long as the building is half a mile or less away from the public transportation.
Now let's get to some nitty-gritty. How long is the construction time from A to Z to finish a project?
So it really depends on the city, right? As far as the permitting goes, the city of LA is probably the best as far as the speed of the plan check goes. Once we get the approval from the client that they're gonna go ahead, the engineer will submit everything within a few weeks to the city. The plan check typically it takes about 5 to 6 months for the plan to get approved. Then we can get the permit, which is going to be another 2 months for what you mentioned for the housing, which is called THB for the city of LA, that we have to notify the tenants that this is what's going to be happening. That's the time if they want to appeal. Once we get the permit, depending on how big the ADUs are, but usually they can go anywhere from 3 months to 8 months. If it's attached, it's going to be faster. Detached, obviously, it's going to be like ground up construction.
And last but not least, what's the average cost to do an ADU?
Ooh, that's that's the most common question asked, but we can't really price ADU per square foot because the bigger the unit goes, the smaller the price per square feet. Because we're gonna need the mechanical, electrical, plumbing, all of those. Doesn't matter how small the ADU or the big the ADU is gonna be, we're gonna need those. But they can start anywhere from $120,000 for one attached ADU with the engineering and construction, and they can just go up from there.
Got it. And once again, what's the name of your company, Deli?
Our company is Sturdy Builds. That's STURDY Builds BUILDS.
And what's that phone number?
Ooh, I don't even know. It's
Well,
good question.
I'll tell you what the phone number is. And it is going to be in the show notes, everybody, okay? But it is 833 sturdy STURDYB So 833-STURDY-B or 833-788-7392. But it will be in the show notes if you watch the edited version, which comes on about a couple hours after the show. Anyway, thank you very much. I
Thank you
appreciate
for having me.
you're joining us here. And
Thank
we're now going to open it up to questions and answers. And we know the rules, and that is that this is just for informational purposes only, is not a substitute for legal advice. If you do have a question, please electronically raise your hand, and I will be happy to call on you. Again, this broadcast is for general legal questions only. If you have a specific case with me, please call me at the office because we don't talk specific cases here. If you are talking to me, put your camera on because it makes it much more enjoyable for myself and for the audience. And again, you guys who are watching this on YouTube, please hit that like button and we'll be sure to appreciate that and subscribe to the channel. And again, if you have questions and you're in YouTube, just put it on to the comments and I'll be happy to answer it this week. And with that, we're going to move on to our first caller, who is Navert. I'm going to ask you to unmute yourself. Navert. Okay, we'll move on then. Let's do to Farouz. I'm going to ask you to unmute yourself.
Hello.
Hi there.
Nice to meet you. Actually, I just discovered you. And let me put my video on as well because it's only fair. It's my first time on your site. I own a condo in the city of LA that has been rented since 2008. And I just every once in a while I would increase her rent like 3% here and not the next year, not the next year. And this year I need to sell the unit, and all of a sudden I realize that I have lost all these rights as the as the owner of a property. It is a condo, and so I realize that it is not subject to rent control, and I can raise the rent more than the 3% that is mandated this year. I'm having a little difficulty getting access into the unit to show it and also to buy her out, to get her to maybe move out so that I can list it. Finally, I decided maybe I can just list it as it is and I will give the relocation fee to the owner so that they will figure it out between themselves. I'm looking at all the city information regarding relocation, and I'm confused about a couple of things, and maybe you can help me understand. It says effective July 1st, 2025 through June 30th of 2026, single family dwelling owned by natural person, relocation for if the owner wants to move in is 1 month rent. And then it has another column that says tenants renting units in mom and pop properties only for owner of family or family occupancy
Okay,
fiction.
let me stop you here.
Yes,
You don't have the right to get there because you're not moving in, you're selling the property, and
correct.
under any circumstance, you're not entitled to ask a tenant to move because you're selling the property.
Correct.
However, once you sell the property, the new owner can then apply to the city, and that they're going to have to pay relocation based on whether they're over 62, children, or whether it's a mom and pop situation where they don't own more than 4 units in the city of LA.
So let's assume that this is the information I want to give to the prospective buyer. I realize that I don't do this. I understand
Right.
that. So let's say the buyer just wants to buy it and move in themselves, and they don't own any other properties. It's for them to move in. Would I, because I want to give them as part of a credit to the selling price, what they might have to pay my tenant in order to move. So is it 1 month's rent or is it 10,200 rent? What is single
Okay,
family dwelling? Is it a house or any kind of dwelling? What does that mean?
I can tell you.
Thank you.
It constitutes a single family home. It does not constitute a condominium. So you
Gotcha.
don't get that 1 month's rent.
Yeah,
Okay.
excellent. Okay, so just for me to know. So it's 10,200 that they would have to pay to my tenant to move. Correct?
Yes.
And if I'm not able to sell this,
But unless your tenant doesn't have children
nothing, no children,
and not over 62.
she's not, she's under
Okay,
60.
then you're correct on that.
Okay. And then one more question is I just because of the Costa Hawkins that I just found out about, I was able to raise her rent more than the 3%. Am I not allowed to raise it again for another 12 months? And when I do, can I bring it up to market or is
You
there?
can definitely bring it up to market. I would wait until November 1st due to the quote state of emergency due to the fires that occurred in LA County. But that state of emergency will be over as of October 31st. So you can raise it again as much as you like. If you're curious as to how much you should raise it by, again, if you raise it in any 1 year period more than 10%, it's got to be a 90-day notice plus 5 days for
Gotcha.
mailing. But if you go to a website, which I've always recommended, called rentometer.com, you'll find out what the value is in terms of other similar rentals within that area.
Okay.
So that's one way to at least get the tenant to move. Now, you might want to serve the rent increase notice
I did
where
already.
he's now at market value and or wait at least till November 1st to do so, and then come to the tenant and say, look, I know this is a substantial rent raise. However, I'll tell you what, don't pay it. I'll give you $10,000 and get out. Make a deal with them, but at least you kind of have a gun pointed to his head with that rent increase, which might incentivize him to take your relocation money.
Yeah, I already sent a rent increase notice for just 8%. Like I gave them 45-day notice for rent
Right.
increase at
Perfect.
November 1st. But I was just wondering if I'm not able to sell this and I'm kind of stuck with this because nobody wants to get a unit and not and be stuck with a tenant, then if I'm stuck with it, do I have to wait another 12 months before bringing it up to market, or can I do it like in the next 6 months, for
You can
instance?
do it immediately.
Okay, but I'm not going
Do it
to.
every
Okay.
month if you like.
All right.
Anyway, thank you very
Thank
much.
you. Thank you.
We are going to move on to, let's go back to Navert because I think you figured out how to do it. Could you unmute yourself? Navert. Okay, well, we tried. Let's go to Duke. How are you? I'm going to ask you to unmute yourself. Mr. Duke.
Hi, sir. Thank you so much for allowing me to ask this question. I have a single family home in the city of Santa Ana. All the bedrooms are leased out individually, month to month, to different individuals. I have a person that's been living there for 4 years. I haven't raised her rent at all. The last 2 months, August and September, she has not paid and has shown zero indication that she will pay. I have served her 3-day pay a quick notice using your free web notice on your website. So she has passed that deadline. I served her on July 28th, and on August 1st, which is after the 3 days, she started paying me $50, and then a week later, $100, and so on and so forth. So my next step is I would like to take the next step to get her out, and
Okay,
then
well,
hopefully,
first of all, what city again is this?
City of Santa Ana in Orange County.
And you say that you're renting rooms. Is that what I heard?
Yes, individual rooms to individual
Okay.
people on a month to
So
month.
once you took the a partial payment, we're going to need to serve a new 3-day notice. Santa Ana has some specific rules and notices that have to accompany your 3-day notice because, as you might know, they have their own rent control. So just call the office and we can prepare a proper 3-day notice. And you're not going to accept a partial payment, only the full payment. And unless the full payment is made within the 3 days, we'd be able to proceed forward with the eviction.
Would it matter? She has a signed lease with me, but she decided to sell my wife instead. Does that have any relevance?
No, but if she does sell your wife a partial payment, your wife will either sell it back or you'll deliver your personal check to them for that same amount because you're not going to accept a partial payment.
Even if it's after the 3-day notice?
After the 3-day notice,
Yeah.
you're not to accept any rent whatsoever.
Oh
If you
gosh.
accept
Okay.
rent, then you're waiving everything.
Oh shoot. Okay. Okay. Um, may I know like the cost to get her out?
I would just call the office though. We'll go over the cost with you.
Got it. Well, thank you so much for your time, sir.
All right, take care. And moving along to Margaret O'Brien. How are you today?
Thank you. My question is the following. I have a rent control unit and I could have given the people a 3-day notice for cause, but the people don't want anything to do with the court and they promise to move out this weekend. Now, it's less than 1 year. Do I still have to pay interest on the security deposit?
No, if it's less than 1 year, it doesn't come into play. They have to be there a year, and then the year's interest comes into play.
Okay, that's my question. Thank you
Good.
very much.
You take care, Margaret. Moving on to Dimex. I'm going to ask you to unmute yourself. Hello there, Dimex. We got a lot of raised hands today. Nobody knows how to unmute themselves. Let's move on to Carlos Garfias. I'm going to ask you to unmute yourself.
Yes, Dennis, how are you?
I am good, thank you, sir.
Thank you. Real quick, this landlord that I represent, he has two duplex. I mean, a duplex, and now the lady in the back, she almost, kind of like every 2 months, she sent the payment very late. So this time on August, he sent a letter of 3-day notice for her to pay or quit. And then right after what happened, I don't know how the Los Angeles Housing Department sent a letter. This is in LA City, which is a rent control, and they sent a letter saying that the landlord sent a letter illegally about this 3-day notice because of the amount do not exceed 1 month of the first market rent. She pays only $652 for this 1-bedroom house, and they say, oh, and he forgot to put the number of the bedrooms of the rental unit as required by the Los Angeles section. And then they say they say that they need to receive documentation that these documents has already been canceled. And
let me stop
saying,
you here because I have the answer to this.
I'm sorry.
Number one, the landlord does need to send the tenant a letter that they're withdrawing that notice. Under the LA City rules, you have to have a certain amount before you can serve a 3-day notice. So if the rent's, how many bedrooms do you know?
It's on 1 bedroom.
Okay, so I think for a 1-bedroom, it's like $2,086. So you can't serve a 3-day notice unless it exceeds $2,086, which would probably be about 4 months worth of rent. This is the insane law by the city of Los Angeles. Also, the city of Los Angeles and also unincorporated areas of LA County do require that you have the number of bedrooms contained in the notice. So based on the moronic laws for the city of Los Angeles, they are correct in saying that the landlord in that situation has to withdraw the notice.
Okay, but what kind of documents does he need to send to the LA City? Because he said he already sent a letter to the lady that.
Well, I would have to see the letter, but I think the letter is saying, and I've seen similar letters, is that you have to withdraw the notice. So if you just sent the tenant a letter saying I withdraw that 3-day notice, then you're fine.
Okay.
You want to also send a copy to the city, that certainly couldn't hurt.
Okay. I appreciate it, sir. Thank you very much.
Okay. Okay, moving along to Kevin P. How are you, sir?
Hello again. How you doing?
I am good, thank you.
Thank you for doing all these educational sessions for all of us. I spoke to you once before, and I just wanted to run a scenario with you. I bought a duplex, LA City RSO. One is vacant, the other one has a long-term tenant over 24 years. One adult mom, she is 70, and one adult daughter. She is 28, I believe. Anyway, so we want to do a grounds up construction there. So we want them to leave. And I just, after buying it a year ago, I just noticed that the boyfriend of the daughter lives there. And the couple of times that I've been to over there, I see that he's always there. So the question is, do I have a real case of evicting them saying that the boyfriend is there? Or since the fires, I'm being told that the courts, they don't really accept this type of evictions anymore.
This is in the city of Los Angeles, correct?
City of LA RSO, yes.
Okay, so if the rental agreement states who can live there and they have additional people living there, then you have the right to commence an eviction. There is a law in the city of Los Angeles that if that extra person was displaced because of the fires, which I would probably doubt, then technically you're going to have to wait until November until the state of emergency is over. But I think he probably just moved in. So, and when he moved in, which would tell you, obviously, if he moved in prior to January when the fires occurred, then obviously it would have nothing to do with the state of emergency. So we could definitely serve a 3-day notice to perform or quit, giving your tenants 3 days to rid themselves of this additional person. And if they don't, we have grounds to evict.
And just to follow up on the same scenario, if is it true that it has to be exactly within 30 days of purchasing the building that you have to act on it, and after 30 days, it's much difficult to do an eviction? Is that true?
And the answer is no. It has nothing to do with a 30-day time period. So if they've got an extra person there, it wasn't approved, you have the right to stand on your rights and proceed with a notice to perform or quit.
I see. Sounds good. Thank you very much.
And thank you. We are going to move on to an old buddy of mine, Harold Rhodes. How the hell are you?
OMG, man. Bro, this is so cool. You have that ADU lady on. That is so killer because I was thinking about it. But I don't know if I want to ask that as the question. The question I want to ask about is, when the contract for the tenant to sign and it says you have to maintain a certain amount of insurance, as a landlord, City of LA, single family residence, just cause. As a landlord, is there anything on my responsibility to make sure he has the insurance?
Well, again, you can't force a tenant, you can't evict a tenant because there's a provision in the rental agreement which requires them to have renter's insurance. There's been case law that states that that's considered, believe it or not, to be a trivial breach of the contract. However, the only reason why you want to have that phrase in your contract requiring tenants to maintain renter's insurance is because this way the tenant can't come back and sue you if, in fact, through no fault of the tenant's, his personal property is damaged, or, for example, if he has to temporarily relocate, maybe because there was a flood in the unit, now he's asking you for compensation. So you want to have that phrase in your contract which says, look, you were supposed to have your own renter's insurance. You can't come at me now and sue me. Your only remedy would be to sue against or make a claim against your insurance company.
So if it was a car form, would it work, or do I need to add that additional language, or you don't know?
I'd have to see the car form. I know my rental agreement states specifically that it covers any that your renter's insurance was your sole remedy for damage to your personal property or if you have to relocate.
Okay, very good. Thanks, Dennis.
And thank you, sir. Jim Polina, how are you, sir?
Hey, how's it going? Can you hear me okay?
I can. What do we got in the background there?
That's my backyard, Morro Bay, with a gondola.
Is that you on the gondola?
No, I'm on the shore taking a picture.
I see he's not moving, so I guess it's a still camera.
It is. Yeah, he was posing. So, Dennis, I have 2 questions, one with insurance and one with 1482. So with the insurance, if there is a situation where, say, flood and the tenant has to move out for repairs and they do not have insurance, are they liable for the rent?
Okay, if they have to move out because there's a problem with the premises that the tenants didn't cause, all you're responsible for is to not charge them for the time that they couldn't use it. So it'd be the per diem rate.
So they are responsible for a portion, so that's a yes answer. They are responsible for the rent.
But not for the time that they were displaced. So if they had to move
I gotcha.
from the property,
And if
the
want
rent's $3,000, for example, then it's, well, whatever that is, it's, what is that, 33 No, it's be
$100.
$100 a day. So for the amount of days that they couldn't use the unit, you subtract $100 per day.
And if they want to end the lease, are they allowed to?
I would have to look at the terms of the lease. If the lease says if the premises are partially or wholly destroyed, then you can terminate the lease. Generally, that wouldn't be the case.
Oh, interesting. Okay. All right. Second question. I'm on the verge of taking a single family home and convert the garage into an ADU. And I'm thinking of offering a lower rent to the existing tenants to stay there during construction. At what point in time regarding 1482 does it apply to the house or the ADU?
It doesn't apply at all. You can start the construction, just serve them with a 30-day notice that you're going to start construction, and you're not allowed to use the garage anymore. There's no relocation or anything that you can do. However, once the unit is constructed, well, first of all, is that garage attached to the house or is it separate from the house?
Attached.
If it's attached, then both units immediately become under statewide rent control, which means that you better make sure that the rent on the house is market value, because then you're going to be limited to statewide rent control, which at least in the LA County area is 8% this year.
Got it. Super. Thank you, Dennis.
All right, Jim. Nice talking with you as always. And we are moving on to Ehab. I'm going to ask you to unmute yourself. Are you there, Ehab? Got to hit your unmute button. Okay, we're going to move on then to, let's move on to Jordan. Jordan's iPhone, how are you?
Good, Dennis. Thank you for taking my call. So my question is, I have started the eviction process with a particular tenant, and she hasn't paid her rent for like 4 months, claiming uninhabitability. I think she's making up a lot of it. And I recently found out that she was in a car accident while running from the police and got into then another accident and is now in the ICU. I know this doesn't sound great, but she's been stealing from me for 4 months. So I'm wondering, can I put a notice of abandonment on her door? And if she doesn't see it and take it off in whatever the 18 days, can I consider it abandoned?
And the answer is no. You have to have a reasonable belief that the tenant has abandoned the premises before you can issue a notice like that. Based on your fact situation, you know for a fact that she hasn't abandoned. She's in the hospital. So
I mean,
you
I know
can't.
it's shady, but she's just, she's a terrible human being, in my opinion. And I don't.
Well, whether she's a
But
terrible human being or not, it doesn't give you license
I-
to write your own laws. So you're
No,
going to have to go through the eviction process.
Which, yeah, I am. But it's going to take a while. Okay. Well, thank you.
Okay. Well, I see we have no more questions, so I want to thank everybody for coming out this Saturday. And we're going to be doing it next Saturday at 3 p.m. Again, my prayers to Charlie Kirk and his family. And with that, ladies and gentlemen, everybody, you have a great weekend.